day.
All right. We'll call our second case 127499 Omar Diosdado versus HG. I'm sure I'm saying that name wrong.
Yes, you are.
Council would like to come forward and enter their appearance.
No, she missed.
To the podium.
We're being recorded, so you need to be at the podium.
Tyler Childress for the plaintiff appellee.
And would you like rebuttal time?
I believe appellant will get that.
Oh, I'm sorry. Okay.
Katie Alsobrook on behalf of appellant HG.
Thank you.
I would just like to clarify, I entered my appearance last week, so I thought.
Yes, we did receive that, but since I don't have face with name.
Understood.
Okay. All right, Ms. Alsobrook, let me proceed. And would you like rebuttal time?
Yes, Your Honor, please, 3 minutes.
All right, you may proceed.
May it please the court. As I indicated, my name is Katie Alsobrook, and I'm honored to be here representing appellant HG today, the defendant in the underlying invasion of privacy, intentional infliction of emotional distress, and defamation claims brought by the appellee, Omar Diosdado. As the court is aware, and just by way of procedural background, at the time of the incidents giving rise to this litigation, both HG and Mr. Diosdado were employed as police officers with the Overland Park Police Department. Also during that time, Mr. Diosdado and HG were friends, not only coworkers, but friends. On or about March 16th, 2023, HG went over to socialize with Mr. Diosdado at his home in Wyandotte County. During that evening and into the morning hours of March 17th, 2023, HG was she believes that she was sexually assaulted and raped by Mr. Diosdado.
And that criminal case has not been resolved. Is that correct?
It is not, Your Honor. In fact, it's set for trial next month, early next month. Following the events of that evening, HG disclosed her belief about this sexual assault and rape that had occurred to some of her coworkers, and ultimately reported the sexual assault and rape to KCK police officers, police detectives. And as a result, criminal charges against Mr. Diosdado were filed. He is currently charged with rape, aggravated sexual battery, 2 counts, criminal restraint, and battery. Additionally, following the incidents that occurred, but before the filing of the criminal charges, HG filed a petition for protection in Johnson County, which is where she lives. Subsequently, that case was dismissed after conditions of bond were entered against Mr. Diosdado, which she felt addressed her safety concerns. On September 18th, 2023, Mr. Diosdado filed the instant lawsuit against HG, alleging the torts of invasion of privacy, intentional infliction of emotional distress, and defamation. And in the petition, Mr. Diosdado specifically references HG's statements made in her petition for protection and the criminal information that was filed against Mr. Diosdado in Wyandotte County, charging him with the crimes that we've discussed. We are here asking the court today to reverse the trial court's denial of HG's motion to strike under the Kansas Public Speech Protection Act, KSA 60-5320, because while the court agreed the subject of Mr. Diosdado's claims involved the exercise of rights protected under the act, it erroneously found that Mr. Diosdado established a likelihood of prevailing on his claims by presenting substantial competent evidence to establish a prima facie case of each element of each of his claims.
Ms. Alsobrook, and am I pronouncing that right?
Yes,
Okay.
Your Honor.
So basically it's two parts, correct? She has to prove that these are statements that are protected, and he has to prove that there's a likelihood that he could win.
Yes.
So let's unpack that first issue. How do we differentiate between the statements made in the PFS versus the statements she made to her colleagues regarding what happened on the evening of March 2023?
Well, Your Honor, it's our position that under the act, all of those statements are privileged because they relate to the judicial proceedings, be them either the petition for protection or the criminal information against Mr. Diosdado.
I think you're going to ask how does statements to the coworkers, how does that enter into the judicial proceedings? I could see the PFS would be certainly entered in as possibly an exhibit at the trial, but what about those statements she made to coworkers?
Well, I think there's a couple different things to consider. First of all, HG's coworkers are all police officers. Yes, they're in a different jurisdiction, but these are the people who she trusts to speak to about what happened to her. And as I'm sure the court's aware, during the process of disclosing a sexual assault, it's a process. And there's always the first person that someone discloses a sexual assault to. So these people that she told were her trusted friends and coworkers, but they were also police officers that encouraged her to report the rape to.
I still don't see the link between speaking to them after the incident and how this relates to a judicial proceeding.
I think, Your Honor, because of the wording of the act is so broad, it defines exercise of a right to petition, meaning any of the following: a communication in or pertaining to a judicial proceeding. I think that telling someone that you've been sexually assaulted and or raped, which then results in a criminal information being filed against someone, arguably pertains to a judicial proceeding.
Wait, I'm going to stop you there because I've read affidavits. You've read affidavits. We've seen the charges in that affidavit, and I don't know if you have contact. It wouldn't say HG made statements to her coworkers. It wouldn't say that, correct? It would not have no. It's not. I'm trying to figure out how that's relevant to the criminal case. They're not going to be brought in to testify, et cetera.
I think they might. Depending on, that's the problem here, because we don't know what statements are being complained of other than the statements that are made in the petition for protection and the statements, I guess, that led to the criminal information being filed, because Mr. Diosdado does not explain in either his petition or in his affidavit what those statements are. In fact, I think in his affidavit, he suggests, and this was the whole reason for their filing a motion for limited discovery, he's suggesting he doesn't even know what those statements are, which goes to the second prong of our analysis. But if he doesn't even know what those statements are, how could he possibly be able to show that those statements were made with actual malice, that they're, well, number one, that they're false, that they were made with actual malice, and that those statements caused him reputational harm and damage.
You just said actual malice. Is that phrase used at the hearing? that occurred?
Um,
Malice, is that discussed at all by the parties?
at the actual hearing, Your Honor, I don't know the answer to that.
And if I were to look through all the pleadings that were filed with the district court, and would I see the word malice? I mean, we could look at the record ourselves, but as someone who prepared it. I'm not trying to trick you. I really just
no.
have an honest question.
I would be lying if I told you one way or the other. I'm sorry, Your Honor. I don't know if we discussed that at the hearing or in the motion. Again, because of the kind of confusing procedural nature of the case, Mr. Diosdado did not respond initially to the motion with a response in opposition. He responded with a motion for limited discovery, kind of a hybrid motion that also attached an affidavit. So
when the judge makes the ruling, I find that there's sufficient evidence here that he is likely to prevail. Did you object and say, Your Honor, we haven't discussed malice?
I do not believe I said I object, no.
And you might not need to, depending on the privilege, right? Whether we have absolute versus limited.
Yes, Your Honor.
So depending on the results from the jury trial next month, would that make this case moot?
I don't think so, Your Honor. I mean, we all know that juries do what juries do, and I don't think that the result of that trial necessarily bears on the statements that were made in this case.
Well, the district court, correct me if I'm wrong, found that statements made in relationship to filing the PFA were qualified.
I think the district court found that all of the statements made were protected speech under the act. The district court did not address whether or not the statements were absolutely privileged, and therefore were not able of supporting liability for plaintiff's claims, which is our position that all of the statements at issue, because the only ones we are clear about are the ones that are made in the petition for protection and the ones, I guess, that led to the filing of the criminal information. But the trial court found that all of the statements at issue were subject to privilege under the act.
So there wasn't a separate finding that on the public official piece, the court lumped them all together under the judicial piece.
That's correct.
Okay, I have a question about the statements. So in briefing, opposing counsel spends a considerable period of time highlighting the fact that these statements to coworkers and things of that nature were not in the way that you framed them in your motion, that you had only had these two categories and they fall outside those categories. But my understanding is that the manifestation or the original manifestation of those two categories was in his petition, which was the PFS and the complaint. So help me understand, it was the way then you responded. Does that undermine his assertion that you went outside the scope because you had raised only these two categories? Or were you limited to those two categories because that's the way he framed it in his petition? Does that question make sense?
Yes, Your Honor. I think the answer is we were limited to those two categories because that's how the petition was phrased. And although the petition does say she made other statements it says just generally she made other untrue statements. However, without stating what those statements are, it's our position that it would be impossible for defendant or for plaintiff to meet the second prong of the analysis if the court even got there after finding that all of the statements were subject to the absolute privilege.
And the next question I have for you, on the court's finding that he had a substantial likelihood of success. Is it your position that the court employed the wrong test in arriving at that conclusion, or that it's not, it doesn't have an evidentiary foundation to support that conclusion?
I think both, Your Honor. I think at least on the record from the hearing, the court did not consider each element of each of the claims in determining whether there actually was competent substantial evidence to support a prima facie case of each claim. And then additionally, it's our position that the statements in the petition and affidavit filed by Mr. Diosdado do not present substantial competent evidence to support each element of each claim.
Thank you.
So again, I want to focus on the two issues in appellant's brief, issues 3 and 4, which again are the trial court's failure to consider the absolute privilege afforded the statements made in connection with judicial proceedings, and 4 are the trial court's failure to consider each element of plaintiff's claims when analyzing whether plaintiff presented substantial competent evidence showing a likelihood of prevailing on his claims.
You are getting into your rebuttal time, so if you would like to wait and cover that in rebuttal, that's fine, or you can proceed if you would prefer and just not do your rebuttal.
I'll go ahead and do rebuttal.
Okay.
Your Honor. Thank you.
Hey, please the court. As the court has pointed out in its questioning, we come down to really a two-step process here. On step 1, we believe that I think the question of whether statements to third-party coworkers fall under this privilege, I think is where a lot of this hinges. We would agree that statements and things related to the PFS and the criminal case directly, especially as she reported it to KCKPD, those things would qualify under step 1. But when we're talking about the third-party coworkers that she talks to prior to reporting this to the actual investigating authorities on March 31st of 2023, just because those third-party coworkers are police officers, our position, that does not mean they qualify under this privilege somehow of being involved in the judicial process. It's clear from the way it's been characterized by the appellant, as well as how it's just characterized in the record. She's talking to them as coworkers, as friends. She's confiding in them. She's not going to these police officers that work for Overland Park PD in a way to somehow advance this judicial or criminal process. They're unrelated. I understand their position. If the crime had occurred in Overland Park, that would be a factor that I think complicates our analysis, because then it's hard to parse what exactly their role was. And I think it's a much clearer, they have some role and they probably have a duty at some point to report or investigate that. But here, crime is alleged to have occurred in Wyandotte County. These police officer coworkers and their coworkers of Mr. Diosdado, as well as the appellant, they have no role in this process. They can't investigate the crime. They can't submit charges. They are here and they're being given statements because they are a third-party coworker that she's confiding in because of this incident.
Weren't they referenced in your petition? I mean, there was an awareness by Mr. Diosdado. So how else are those to be addressed? Because he included them in his petition, and in his petition includes those two categories.
Yes, Judge, it does. And I think that that's imprecise pleading, perhaps, by trial counsel. But in that petition, he does point out that she has made numerous statements to third parties. And so it encompasses this. But I think what's also important for this specific statute, because it happens so early in the process, I mean, this is at the very beginning of this civil case, the affidavit can and should be considered by this court. The decision made for steps 1 and 2 is not reliant only upon the petition. The case law makes it very clear, as well as the statute, that the court looks to any of the pleadings, which would include our petition, but the court also looks to affidavits, which would include Mr. Diosdado's affidavit. I understand that on appeal, appellant has objected to what they believe is an insufficient affidavit, but they didn't raise any of those issues at the trial court level. It was entered, it was considered by the trial court. And so I think when the court is looking at everything, it's not just the PFS and the criminal proceeding that are included in the petition. And I would agree that under step 1, those would qualify. I think that's very, very clear that under step 1, we would move to step 2. But in relation to those comments made to the third parties, the co-workers, we do not believe they qualify under step 1. I just briefly want to point out that
Before you point something
Okay.
out, I'm going to stop you there. There's 2 parts of privilege under the statute. Isn't that correct? There's absolute and then there's qualified.
that is correct, Judge.
What would be your argument against finding that her statements to the third parties was qualified privilege, given that he is a public official?
That's exactly where I was going, Judge. The appellate cites to Rollins versus Redmond. Redmond, I think it's really critical to look at that case as centering on the fact that Mr. Redmond ran for public office, and there's dicta about his prior work as a police officer before retirement, I think about a decade before he ran for office. But ultimately, the holding centers on he ran for public office. The article was about him losing that election. And frankly, also the fact that the comments about him being an officer were related to his actual duties and his performance in that job. When we look at Rollins, the court broadly talks about police officers and finding that they are public officials. But what I think is really important for this court when they're looking at Rollins, it centers on on-duty conduct. And so in that situation, Rollins had committed harassment against a female while on duty. I think it's also important to note in that case that he never ultimately denied the general truth of what was happening there. And so while there's a general discussion by the court in Rollins that all police officers should be considered public officials, that was not determinative of the holding in that case because all of their discussion centers on his on-duty conduct. In fact, in the holding, there is mention kind of thrown out casually, and I think it's because it just wasn't in front of the court. And in a case like this, it's got more significance. They point out that it regards his on-duty conduct, not conduct in his private life. And so our argument would be he's not a public official in the sense that this is off-duty conduct and it does not have anything to do with his role as a police officer. I understand they're arguing that there's a public need for this information, but we don't believe that the case law supports that. However, I do agree that if this court finds that a police officer in any situation, whether it's private life or public life, is a public official, then I would say the appellant has probably met the burden for step 1 and we would move to step 2. We don't think they've met that.
But isn't the fact of whether the allegation relates to their on-duty conduct, isn't that only relevant for purposes of triggering whether actual malice is required? So the only significance would be that if it relates to his on-duty conduct, then she has the additional burden of showing actual malice. But otherwise, he can still be a public official and it could still fall under that piece of this statute without it pertaining to his on-duty conduct. The only relevance with the on-duty conduct is that she would then have the additional burden of actual malice. Isn't that what Rollins and Redmond really say?
I would agree that that is the ultimate issue that they are getting to. I think the appellant uses those cases to argue that under this anti-SLAPP statute, because of this public nature of his position, and they don't distinguish what he's doing on duty or what he's doing off duty, that follows under the prong of the statute regarding the public interest in safety and well-being. And so we don't believe that they've met that under these. And I agree that as this case has progressed, I think you've seen from the district court to now the appellate court, additional issues have percolated through that were not addressed at the district court level, which I know is not helpful for this court in trying to determine how to go forward. But I would agree that those two cases are more towards malice and whether there's going to be success in moving forward on the actual claims of damages when you get into the actual merits of the case.
But the actual malice, I guess, and maybe you're answering this and I'm just not picking up where you're going. The actual malice isn't always required hard stop.
I would agree with that, Judge.
Okay, so he could just be a police officer and that would satisfy the public office piece or the however the statute phrases it.
I understand where the court's coming from. I think that's a reasonable interpretation. We disagree that a police officer is always in a public official capacity, no matter what they're doing.
So character doesn't factor in too.
No, Judge, I think character would factor in. I guess it depends on how broadly this court is going to interpret 60-53-20. If the court is going to view the prong about public safety, well-being, et cetera, very, very broadly, then I would agree with your position.
I'm gonna ask you, a police officer charged with rape, that's not a broad reading of public safety, wouldn't you agree? That's not broad. That's very, very black and white, wouldn't you say so? So I'm pushing back at the fact that you are saying or implying that that's a broad reading.
Judge, I take your point. I'm not trying to minimize. I think from our perspective, Mr. Diosdado is adamant that he did not rape her.
Right.
And so given that this happened, this incident occurred in his private life, we would just object to the public official finding. But I think the court, it sounds like, is leaning towards making that finding. And so I'd like to move on to step 2, which is where I think this all comes down to.
Well, it's not necessarily leaning towards that finding, but you would have to agree that this is a very slippery slope when you have individuals charged with a crime who are then pushing back against victims and creating additional potential trauma, that we have to be very careful in how we proceed. This is kind of hallowed ground, I guess I would say.
I would agree, Judge, that this is a very sensitive issue and that this court has to be very mindful of how this is going to affect future cases. Because frankly, for Mr. Diosdado, for the appellant, it's obviously very personal to them. We understand this is going to have far-reaching ramifications. From our perspective, if Mr. Diosdado is falsely accused and there's a defamatory statement, all the different claims that we've made, and this court finds that the statements to third parties that are not involved with this court process, that the district court should be reversed and that he can't bring these claims forward, he essentially has no recourse for the damage that has been done to him publicly.
And we are sensitive to that as well. I want you to realize that we do have an equal balance. I was just trying to stress the importance of where.
No, and I understand it's a very difficult position to be because these, as the court knows, don't frequently come forward. A lot of times it's just a criminal case and that is it. But that does not mean someone in Mr. Diosdado's position does not have the right to petition a civil court for redress for claims that he believes are false against him. And so when we turn to step 2.
And I'm going to pause. Aren't you glad you finally get there? We finally let you get to step 2. Continue.
And Judge, I think that based on Northeast Comanche, this court doesn't even necessarily have to deal with some of the issues on step 1. I think it can just jump to step 2, because if we prevail on step 2, a lot of this difficulty on step 1 that maybe this isn't the best case for determining those issues, you don't have to reach. And so I think Northeast Comanche is a good roadmap for where this court could go to affirm the district court. Mr. Diosdado, as part of the motion for limited discovery, which he's allowed to request under the statute, included an affidavit. In that affidavit, he specifies conversations that he has become aware of that the appellant made to John Brown and Tara Stevens, as well as 2 coworkers. It's unclear whether that's 2 or 4 people. That's one reason why limited discovery would have been helpful for the appellee to pursue. And so The first argument I think can be easily dealt with. The statute does not require a pleading in opposition as the appellant is trying to get this court to read into the statute. But I will note in requesting limited discovery, it's very clear that Mr. Diosdado opposes this motion by the appellant and that we are pushing back on the idea that there is no evidence of statements being made to third parties. And so when you look at that, yes.
Why didn't you wait to file this litigation until after the criminal proceedings were resolved?
That's a good question, Judge. As this court is very well aware with criminal cases, it's outside of everyone's control, appellant and appellee's control, how quickly that process is going to move forward. That is can be a very lengthy process. And so if Mr. Diosdado just waits, he's running the risk that if something happens in the criminal case or it takes too long, he may not later be able to seek relief through the civil case. And so an additional fact for that is, from Mr. Diosdado's perspective, he did not rape this person. That is how it's portrayed publicly. He's now got the criminal case. He wants to assert his rights to demonstrate publicly that he did not do this and to seek redress for those falsehoods. And so I understand the difficulty that we're dealing with, a very serious criminal proceeding that is still ongoing, as well as this civil process. But to your earlier question about would the criminal case be dispositive of the civil case, I don't think it would be dispositive. I think in certain ways, depending on how that criminal case comes out, maybe it would make the civil case moot or at least no longer advantageous to pursue, especially if there's a very negative inference from Mr. Diosdado at that criminal case. But if he's acquitted, he still has the ability to go forward, seek redress through the civil process. But if he has not filed and he's allowed the criminal case to just percolate through, and we all know there's all kinds of different permutations of how that could go. There could have been a ruling that it goes up on interlocutory appeal that takes a year or two. And so I don't think that the statute requires him to wait. And I don't know that that would be advisable for somebody that has those claims to wait for a process that he doesn't have total control over to play out, that also would not be dispositive of the claims in the civil case necessarily. I understand they're related proceedings, but we do view that they are separate proceedings seeking redress for separate either claims or rights under the law. And so when we're looking at step two, when we're looking at the affidavit, the petition, Mr. Diosdado met his prima facie burden to show that he could prevail. These statements to these third parties, they have nothing to do with the criminal process or proceeding because they're just her confiding in coworkers. In regards to the malice, I would agree that, frankly, I think that has just emerged in the appellate process because maybe the parties have looked at case law more clearly and more fully understand where this is going to go should the court affirm and the process continue. But malice can be shown by either the person knowing the statement is false or reckless disregard for truth. And in this case, Mr. Diosdado either raped appellant or he did not. Those are the two individuals that were in the room when this alleged incident occurred. And so if the statement is false and Mr. Diosdado did not rape the appellant, then that is something she either knows to be false or there's a reckless disregard. And so I think when the court is looking at the record at the district court level, there is information and evidence there where the court can draw that conclusion. And we push back on the argument that Mr. Diosdado.
I want to summarize. So your point is if he's found not guilty, we could show that she's lying?
No.
Okay, good. 'Cause I want you to clarify that.
No. The criminal, civil are separate. I'm saying if in the civil proceeding, the fact finder made a finding that, and I apologize for not being clear because we are dealing with two, I apologize. If the fact finder finds that the statement is false, given the nature of the statement, it's very black and white, it's very limited. there's only two people. It's either his version or her version. I think that inference of malice can be made, even though that's been a late addition to the proceedings. Thank you.
Thank you for your argument, counsel. You have 3 minutes.
Thank you, Your Honor. I want to address Judge Schrader's earlier question to opposing counsel about why Mr. Diosdado didn't wait until after the criminal case had concluded to file these defamation claims, intentional infliction of emotional distress, invasion of privacy claims against HG. It's HG's position and my position that he didn't wait because he wanted to be able to conduct discovery that he's not entitled to just to conduct in the criminal case. And the evidence that supports that is the fact that he propounded discovery to HG with this lawsuit. And then in response to our motion to strike, filed a motion for limited discovery. Opposing counsel is conceding that the specific claims referenced in plaintiff's petition that were contained in the petition for protection and that led to the criminal information being charged are absolutely privileged. However, they're relying on this throwaway statement contained in the petition that she made other untrue claims to coworkers and third parties. They don't identify what those statements are. Because they do not identify what those statements are, plaintiff failed to, in all of the pleadings, including his affidavit, establish not only the falsity, but the actual malice and the damage, the damage which has to be causally connected to the specific statements that they're complaining of.
Well, how can he find out what the statements are if he can't do discovery?
Well, I mean, he's referencing statements, I guess, that were contained in he's referencing statements that he believes exist based on, this is my understanding from reading the affidavit, phone records that show that people spoke to each other outside of text messages. We don't know what those statements are. So,
Discovery hasn't taken place.
Correct. Because instead of immediately filing a motion to conduct limited discovery in response to our motion to strike under the act, plaintiff waited until the final hour and then filed a motion for limited discovery on the date that their response in opposition to the act or to the motion to strike was due.
But wasn't that essentially, I mean, the language communicated that was their intention, even if it wasn't in the language you would have preferred? Wasn't their intention clear with what they were filing? I guess it's my point.
I mean, I think, Your Honor, yes, that his affidavit, which essentially says that plaintiff is lying, or that her statement that she was raped and sexually assaulted is untrue, is trying to respond to establish, their claims that their defamation and invasion of privacy and intentional infliction of emotional distress claims. However, because we don't even know what statements they're complaining about, plaintiff failed to establish substantial evidence of each of those claims.
You touched on something I just want to clarify. When you filed the motion to strike under KSA 5320, at that time, you did not know what those statements were regarding the coworkers and third parties. Is that correct?
Correct, Your Honor.
Therefore, how are you able to show that these statements were privileged? If you don't know what they are, how can you file a motion to strike to follow the statute? Can you help me out with that?
I think the response to that, Your Honor, would be, we filed the motion to strike because the only statements that were definitely defined were the statements that are made in the petition for protection and that led to the criminal information being filed.
And that's what he had identified in his petition.
Right. In response to we weren't specifically responded to other unknown, allegedly untrue statements that they were referencing in the petition. And again, it's our position that all of these statements that were made through the process of HG's disclosure of sexual assault are absolutely privileged. However, even if these statements to these third parties, these unknown statements to these third parties are not privileged under the right to petition, they are privileged under the right specified in the act of the exercise of free speech for the reasons that you previously discussed with opposing counsel, in that they relate to a public official, a police officer, and also to matters of public concern, health and safety. Public official or public figure specifically is set out in KSA C7.
Your time has concluded. If you want to take a minute to just wrap up, that would be great.
Thank you, Your Honor. For the reasons discussed today, we are asking that this court reverse the trial court's denial of HG's motion to strike, direct the courts to dismiss plaintiff's entire case with prejudice, and direct the court to award defendant attorney's fees and costs below and on appeal, and for such other relief as this court deems just and proper. Thank you.
Thank you. Thank you both for your arguments.
Thank you.